our program, Dismantling Institutional Bias and Racism, the Past, Present, and Future of California's Struggle with Equality and Fundamental Fairness. I'm Jason Lee, immediate past chair of the State Bar of California's Board of Trustees and General Counsel at Legal Advisors. I'll be your guide for our 60-year journey through California's civil rights history, leveling the playing field through affirmative action, the passage of Prop 209 that effectively eliminated those efforts in the government sector, and now Prop 16, an attempt to right the ship and provide opportunity for everyone in this great state. The time for this direct conversation is now. California and this country is embroiled by racial justice and institutional bias and racism issues, more recently highlighted by anti-Black racism, the killing of George Floyd, and so many others while in police custody, the Black Lives Matters movement, and COVID-19's disproportionate adverse impact on our communities of color. There isn't anything more American than shining a light on these issues. I'm grateful to have three tireless advocates for justice join me for this discussion. Two members of the California Legislature, Assembly members David Chu and Lorena Gonzalez, and Thomas Saenz, President and General Counsel of the Mexican American Legal Defense and Education Fund. First, I will introduce Assemblymember Lorena Gonzalez. She was elected to the legislature in May 2013, promising to fight for our state's working and middle classes. The Atlantic magazine labeled her the California Democrat, setting the national agenda for her work. Indeed, Lorena's influence has been broad, touching upon many segments of our state. She's been responsible for historic legislation that allowed 6.5 million Californians the ability to earn paid sick leave. She was responsible for the automatic voter registration that allowed nearly 7 million unregistered citizens the ability for lifetime voter registration. She has succeeded in making California the first state in the nation to subsidize diapers for parents. As a father, I can appreciate that. Allowing hardworking mothers and fathers struggling to juggle job and parenting responsibilities. Lorena is the first Latina in California history to chair the Assembly Appropriations Committee. She is also chairwoman of the Select Committee on Women in the Workplace and chair of the Latino Caucus. Prior to being elected to the Assembly, Lorena was a labor leader and organizer. She is a graduate of Stanford University and has a master's degree from Georgetown University and a law degree from UCLA. Welcome. I'll next introduce Thomas Saenz. He is the president and general counsel of MALDEF. Tom leads the organization in pursuing litigation, policy advocacy, and community education to promote the civil rights of all Latinos living in the United States in the area of education, employment, immigrants' rights, and voting rights. He's practiced civil rights laws and spent 4 years at the organization as the organization's litigation director. Prior to assuming his leadership role at MALDEF, he served on LA Mayor Antonio Villagrosa's executive team. He served as lead counsel for MALDEF in numerous cases, including challenges to California Proposition 187, Prop 227, and California Congressional Redistricting. In 2016, Tom argued before the U.S. Supreme Court in U.S. v. Texas, representing interveners defending the Obama administration's deferred action initiatives. Tom is a graduate of Yale College and Yale Law School, and clerk for 2 federal judges before initially joining MALDEF in 1993. Our final panelist is Assemblymember David Chu. I met David when I first returned to the Bay Area about 20 years ago on the rooftop deck of MedJewel in San Francisco. He was the president of APABA at the time. We've known each other for quite a while. David represents the 17th Assembly District, which encompasses Eastern San Francisco. He is the current chair of the Asian and Pacific Islander Legislative Caucus and Assembly Housing and Community Development Committee. He is a strong advocate for the disenfranchised. During his 5 years in the Assembly, David has authored 59 bills that were signed into law, including measures to address the state's housing crisis, protect tenants, and expand protections for immigrants. For 6 years, David served as president of the San Francisco Board of Supervisors. He is the first Asian American to serve in that role, the first Asian American to represent Eastern San Francisco in the California State Legislature. Before running for office, David was a criminal prosecutor in the SF District Attorney's Office, a civil rights attorney for the Lawyers Committee for Civil Rights, president of the Asian American Bar Association of the Greater Bay Area. He is a graduate of Harvard University and received both his law degree as well as his master's in public policy from that same school. Welcome, David. Welcome all. Before we get started, I wanted to thank our co-sponsors, the Asian American Bar Association of the Greater Bay Area, the Asian Pacific American Women Lawyers Alliance, the Asian Pacific American Bar Association of Los Angeles, who are sponsoring our MCLE, the Bay Area Lawyers for Individual Freedom, California Asian Pacific American Bar Association for sponsoring our webcast, California Women Lawyers, East Bay La Raza, John M. Langston, the Southern California Chinese Lawyers Association. And a final note, before I turn it over to David, is MCL credit is available, and I'll be providing you details at the end of this program. So welcome all of you and all those who are watching. I wanted to provide a little bit of context, or have David provide a little context with the history of civil rights as it pertains to our great state, to sort of launch into our discussion about Prop 209 and Prop 16. So David, if you can provide our audience with a little bit of context of where California fits in with our country's history.
Sure. So good afternoon. Thank you for having me on this important discussion. So Jason wanted me to maybe do 100-year retrospective of racism in California in the next 3 minutes. So I'm just going to give a smattering of a couple things just to contextualize where we are in this long arc of history, as Dr. King would refer to, that hopefully will bend toward justice come this November. So just a couple of data points. California, despite how diverse we are and how progressive we think we have a pretty long and ugly history when it comes to civil rights. And I'll just tap through a couple of things that have happened to some of our communities. So our Native American community, our California government, like our American government, not only committed genocide against our tribes, but literally had bounties for body parts, 20 cents per scalp, $5 for a whole head. Let's talk about my community, the API community. I often think about the fact that I serve on the floor of the California Assembly, which was really the first major legislature in the country to pass explicit laws discriminated against people who look like me. So it was in the latter part of the 19th century that the precursors to the Chinese Exclusion Act were passed. It was in 1855 that there was the first anti-immigrant law passed in the state of California, which is really targeting Chinese American immigrants. And then you fast forward a little bit, during the gold rush, there was the foreign miners tax, other discriminatory policies against Chinese immigrants. And then in the early part of the 20th century, 1913, 1920, our state passed our first alien land laws that prohibited immigrants from owning properties. Fast forward to the civil rights times of the 1960s. We often think of that time being a very progressive time period in our country's history. It was in 1964 that California voters overturned the Rumford Fair Housing Act, which was a law that would have prevented racial discrimination in the sale and rental acts when it comes to housing. So for those of you who follow housing politics, I will tell you, as the chair of the Assembly Housing Committee, so much of today's inequities in housing were literally racially baked into our state laws over many, many decades. In fact, a lot of single-family zoning laws in our state today, which we sort of take for granted, came from this very racialized history of wanting to keep African Americans, Asians, and others out. And then just to talk for a moment about what the Latino community has had to deal with, there has been a long history that would take hours about what the largest ethnic community in our state has dealt with. But maybe to fast forward to the current conversation, in the 1990s, there were a series of very racist ballot measures that were pursued and that passed. So that started with Proposition 187 in 1994, which was actually the very first lawsuit I ever got involved in, and a suit that Tom on our panel was helping to lead, which proposed to deny public services, including healthcare and education, to immigrants that lacked documentation. This was followed by Proposition 209, which we will spend most of today talking about, and then followed shortly thereafter by Proposition 227, which banned bilingual education. So these were all the precursors to what we think of as a relatively recent, more progressive past in our state. But in the scheme of kind of our state's history, what the good things that we've seen in the last few years has really been a blip on what has been a much longer, regressive, racist, xenophobic history. So, Jason, that's 4 minutes for you.
Very well done. Assemblymember Gonzalez, there was a time in the state's history sandwiched, I think, between the propositions that David described and in the civil rights movement, where the state did move to initiate several affirmative action programs. Can you talk a little bit about that?
Yeah, and I think it's important for people to realize that after the Civil Rights Act, President Johnson basically said, "Hey, in government contracting, we've got to have affirmative action. We have to actually make sure that we're implementing the Civil Rights Act." And President Nixon followed suit, really pushed, especially on the government contracting side of it. Under President Carter, we started seeing, right before that, a push for educational institutions, nationally. Here in California, of course, there was a famous decision, became part of the Supreme Court's first look, I guess, at affirmative action in education. And that was when the University of California had implemented a program of affirmative action, Bakke versus the University of California, of course, a famous civil rights case, which basically the Supreme Court said, look, you can't have quotas. A numerical quota is not acceptable, but goals and timelines, diversity goals and timelines are. And so after that, the University of California for nearly 2 decades, I guess, 2 decades long, supported that ideal and had affirmative action specifically in education. We continue to have affirmative action in our contracting goals in the state. It wasn't seen as unusual. That all started to change under, of course, Governor Wilson, as we heard, and as an attack on we'd say immigrant communities of color began to unfold. And what is often missed or forgotten about, I guess, in the Prop 209 discussion is it was actually the Board of Regents right prior to the passage of Prop 209 under Ward Connerly, who passed a goal to remove affirmative action from the University of California in the following few years. In 1996, when Prop 209 passed, that really pushed it forward much quicker. Obviously, it was going to be eased in, supposedly. But that's kind of a condensed version of what we had. We had diversity goals and timelines. They were being met by UC, CSU, utilized those. And then around the Pete Wilson era, we had this reversal, if you will, of policy positions in the state. In a reversal, kind of we set the stage really for a lot of states who were looking at that. California became one of the first states to ban affirmative action. And so what we think of now as California, kind of this forward-looking, diverse acceptance of a wide variety of communities of color now wasn't quite like that. In fact, we were at the forefront of taking away those rights and possibilities for so many of our communities in that time frame of the early 90s.
And I wanted to open up to the panel overall. I mean, there is controversy surrounding affirmative action at the time and today. I personally was a beneficiary of affirmative action. My family was a beneficiary of affirmative action, and I think there were generational benefits that inured to whole families in the state. Could you talk a little bit about those benefits? And I'll take the first comer on that.
Well, I will tell my story. I think
Sure.
It's always important for us to acknowledge those of us, and I was the last kind of, I guess, classes probably, I think are from the same kind of years in undergrad and graduate school and law school, where we were the end of the affirmative action classes, if you will. So I definitely benefited from getting into Stanford under their affirmative action program. They still have one, especially for first generation college students. But I got into UCLA Law School with a race-based scholarship. By the time I got to law school, it was 1995 when I got in. It was they were recruiting highly qualified Latinos and African American students who would otherwise be pulled into private schools in order to add diversity into their schools with very generous scholarships, but they were race-based. And so when affirmative action was repealed in 1996, so was my scholarship. I had decided on UCLA because it was diverse and because they were offering this possibility. And so I think we often saw those of us who were kind of in the middle of this change, a complete just a shell shock of what happened. I went from being a first year of a very diverse class to the next year being a sophomore and seeing the first year law students basically have a completely different look. And that continued to happen at our time in law school. And I know continues to happen today, where we haven't reached the type of equity even we had back then, when we still hadn't reached our numerical equity that we would like to see. So for me, just seeing it up close, experiencing it personally, making decisions in my life based on a school that was diverse and who really wanted me there. Who said, we want you to come here and add to our diversity, and having all that cut off and what that means to those of us who are trying to enter fields like law or medicine, or, trying to really understand our place in that kind of field, I think really upset the apple cart, to say the least, and didn't lead to more diversity as it had promised.
I'll jump in. I actually have a comparable story to Lorena on this front. So when I was in college, I was a struggling pre-med student, literally about to fail out of Harvard College, when I learned about a scholarship for ethnic minority students to encourage folks to go into public service, which was a field I was really thinking about. And but for a summer program, which then set me up for a race-based scholarship to get a master's in public policy, I would not be here. It was a program that literally almost every student of color who went through that program attributes that program for why they're in public service today. And in fact, many of us who are serving in office, who are serving in public policy, can attribute kind of our past to the Woodrow Wilson Fellowship Program that encouraged minority students to go into public policy. I often talk about how in California at this moment, we have the highest number of Asian Americans serving in the California state legislature. Many of us benefited from those very programs in the late 1980s and the early 1990s before Proposition 209, and we were just lucky enough to get in to the window right at that time period. But for that vagary of just timing, I don't think I would be here talking to you as the chair of the API Legislative Caucus or as a state legislator.
Thomas?
I'll jump in and say I too was a beneficiary of affirmative action. I went to private university, so those programs continue. Indeed, to contextualize this, we have a national attack, if you will, some of those affirmative action programs at places like Harvard and at Yale, most recently my alma mater. But I certainly benefited from things like a minority recruitment program, particularly powerful in California, particularly active in Los Angeles, where I was. And without that program and the focus of alumni and the admissions office on particularly looking for folks from underrepresented minority groups, and at the time that meant African Americans, Latinos, Asian Americans, and Native Americans, I doubt I would have been recruited or admitted to Yale. I emphasize the recruitment element because what we have been deprived of under Proposition 209 at our public universities in California ranges from not just what is done in admissions, but what's done in recruitment. You cannot have, under Proposition 209, a targeted recruitment program that looks specifically at racial minorities. That would be a race-conscious program that would be barred by Proposition 209. So I think it's important to recognize that what we have experienced under Prop 209 at the University of California, at California State University, because so many of our Cal State campuses and majors are now becoming selective and making competitive decisions about who's admitted, but it also extends to an inability to engage in targeted recruitment, or as my fellow panelists, our two esteemed legislators have both talked about it. You can't have targeted scholarship programs, at least not directly operated by these universities. So what we engaged in as a state prior to Proposition 209 was extensive, even just in the realm of higher education. But of course, it went beyond higher education to K-12 education, to public employment in every public agency statewide, and contracting in every public agency statewide.
Thomas, I'm gonna stay with you. I was having a conversation with a colleague the other day, and I mentioned Prop 209, and that colleague had no idea what that was. She had said she was when I gave her the date, I was in law school as well. She said she was 1 year old. So if you could provide some background on what 209 was and is, and then we could take it from there.
Sure. Well, it has been 24 years, so that is a long time, and we have many voters who will vote in November who may not have been either alive or certainly politically aware at the time of Proposition 209. So we do have a lot of education to do for the electorate about Proposition 16. But I think, as you heard earlier, Proposition 209 came in the mid-1990s. This was an era when we had a number of wedge issues, so-called wedge issues that were racially divisive and placed on the ballot, in this case, by an initiative campaign led by Ward Connerly, whom you heard previously was a UC regent who was appointed by Governor Pete Wilson. His initiative was also heavily supported by Governor Pete Wilson, who campaigned for it, raised money for it, was certainly as much identified with Proposition 209 as Ward Connerly. As you also heard, it followed another wedge issue a mere 2 years earlier in 1994, when Pete Wilson used Proposition 187, an anti-immigrant measure, as a vehicle to boost his re-election campaign. It was characterized by some very controversial ads that showed grainy black and white photos of folks crossing the border, and in tone, "They just keep coming." It was clearly an us versus them type of campaign. What we saw with Proposition 187 in 1994 was an almost unprecedented split in the vote, where all voters of the groups of voters of color voted against 187, but nonetheless it passed by 58% of the vote. Now that was repeated with Proposition 209, a divisive measure where the exit polling tells us that voters of color voted overwhelmingly against Proposition 209. In the end, the LA Times exit poll indicated that 76% of Latino voters voted no on Prop 209, 74% of African American voters voted no on Prop 209, 61% of Asian American voters voted no on Proposition 209. But because their proportion of the vote was not as large, the proposition was passed by 55% of the total vote. Now, what Prop 209 did was added a very short paragraph to our state constitution. It was misnamed the California Civil Rights Initiative by its proponents, and I think it was misleadingly written to include both a prohibition on discrimination, that prohibition being entirely unnecessary and superfluous because both the US and state constitutions had prohibited discrimination on the basis of race or gender by government entities since at least Brown versus Board of Education in 1954. So that was unnecessary, but it was included to mislead some voters into believing what they were doing was adding a discrimination protection to the state constitution. The actual operative provision barred quote unquote preferential treatment on the basis of race or gender or ethnicity in public education, public employment, and public contracting. And that prohibition on preferential treatment, quote unquote, is what has been interpreted to mean no race or gender conscious affirmative action programs in any of those realms. Education, both K-12 and higher education, employment at every government entity from the state down to localities, and contracting in every government entity from the state on down to local transportation agencies, local cities, and the like. So it was a very divisive measure when enacted in 1996 and had immediate effects. We saw effects at the University of California, perhaps most notably the immediate aftermath of Proposition 209. The law school at Cal Berkeley ended up with only one African American student who had actually been admitted previously and had deferred his enrollment for a year. One African American student, a dramatic drop. And we saw similar drops for Latinos across the board at the University of California. So it had almost immediate effects consistent with what its drafters intended, which was to dramatically decrease opportunity, particularly for people of color and women in the three realms of education, employment, and contracting.
Thanks, Thomas. Assembly Member Gonzalez, can you add a little more? You shared your personal story about the impact of the proposition in your law school, and Thomas, everyone focuses on higher education, but the impact was far more reaching than just that. Can you talk a little bit about that impact or those impacts?
Well, one of the biggest impacts and often unspoken impacts really affected white women, to be honest, and that's in contracting. Affirmative action allowed contracts to be affirmatively provided for, racially cognizant and gender cognizant of the contracts that were being awarded. If we remember back in the day, one of the biggest proponents of Prop 209, of course, was the contractors who were kind of the good old boys and getting those contracts. I don't want to disparage anyone, but there was a lot of interest in reducing the number of women-owned businesses and minority-owned businesses that suddenly could really have programs that reached out to them, that helped them, that encouraged them to get government contracts. That's a lot of money. And quite frankly, I think we so often talk about the education piece that we forget that and we so often talk about the racial piece that we forget that the biggest beneficiaries of affirmative action, in fact, were white women. It led to some equities, both in education, but especially in contracting, that were immediately reduced, if not wiped out, as a result of Prop 209, and something that when it comes to, of course, minority-owned businesses, and whether they be Black, Brown, Asian, Native American, really our ability to talk about whether or not we're reaching out on a conscientious basis to racial groups or even to women-owned businesses has been kind of blunted, obviously, from this proposition. It's always easy for those of us, I think, who are in school to go to the education piece, but that is a huge portion of Prop 209 and the impact of Prop 209.
Assemblymember Chu, what were you seeing in terms of, or are seeing in terms of the impact of Prop 209?
Well, I want to just take it back to when Proposition 209 was passed. I remember it because I had just graduated from law school, and I had mentioned I benefited from an affirmative action program to encourage ethnic minorities to go into public service. So when I graduated from my Harvard Law School class, I was the only Asian American that went directly into public service. And my first job was working for the US Senate Judiciary Committee as one of the Democratic attorneys. It just so happens coinciding with when conservative Republicans in Washington, D.C. decided to use this wedge issue of affirmative action. And I remember the discussions that we were hearing about of these white Republicans saying, we're going to bring out our two friends from California, Governor Pete Wilson and Ward Connerly, to come make the national case for why we need to do this. And it really was part of this crazy wedge issue. You may remember around that time, there was this KKK member named David Duke who ran for governor and Senate in Louisiana. And he literally equated affirmative action with Nazism. This was their rhetoric, their way of moving things forward. And what was so diabolical about it, as Tom alluded to, was sort of the language of Prop 209 appears very race neutral. It says the state shall not discriminate against or grant preferential treatment on the basis of race, sex, color, ethnicity, with regards to public employment, public education, public contracting. On its face, it sounds very neutral, but the reality is it has held back true equal opportunity for now a couple generations. You know, you asked the question of sort of where do I see the impact of this? Lorena referred to the impact on contracting. The fact is, California businesses, small businesses of color run by minorities and women lost over $1 billion a year of contracts that we were able to account for. My guess is likely more than that. When it comes to employment, you look at the lack of diversity in so many fields in the public sector, both at the rank and file, but also when it comes to leadership. That is a function of Proposition 209. And obviously the education impacts, as we've been talking about, have been very severe, not just within Black and Latino communities, but also within API communities. We have had many, particularly sub-ethnic groups within the Asian community that have been held back because of opportunities that got shut down as a result of Prop 209. So you look at all that, and then you contextualize it in today's day and age when we're having this very intense national conversation about structural inequality based on race embedded in all sorts of different systems. I think it's a no-brainer for us to say, let's try to reset things so that we can decide area by area, sector by sector, if race ought to matter, if it should be a factor at all in deciding what it means to have a society that really engages equal opportunity.
So I just build off of that. I think that that's the greatest impact of Proposition 209. It absolutely has affected who gets into schools, who gets employed, who gets contracts, but it really has skewed, even perverted, our policy conversation in this state. It started right after 209 was enacted, and as a lawyer, I remember hearing this. The problem is that there were many cautious institutional lawyers advising city councils, advising school boards, advising even the state legislature, who would read 209 and say, oh, you can't even talk about race. You can't talk about racial disparities. You can't talk about gender disparities. That's not permitted. That would be a potential violation of Prop 209. Now, that was an overreading of what Proposition 209 said, but it did really shift conversation away from even attending to those disparities that were in front of everybody's face, if you will. Now, beyond that, we moved on that over interpretation of Proposition 209, but even in the last 5 to 6 years, and I know, again, from being at MALDEF and having the request come in, that even when the state enacted its local control funding formula for K through 12 schools, now that's a race neutral program to send additional funding to serve foster youth, those from low socioeconomic status, and English learners. Now, those are all race neutral categories, but the legislature had very serious concerns about whether that would run afoul of Proposition 209. Why? Simply because those categories do overlap with racial minority groups. But it is on its face race neutral, so there's really no Prop 209 issue, but there was significant caution about whether the state could engage in that. So those are just some examples of how I think the biggest impact has been skewing, I would even say perverting, our policy conversation in this state on significant issues like the ongoing racial and gender disparities that we see in education, employment, and contracting.
So over 20 years later, most of the country has found themselves at home due to the COVID pandemic. We've seen and heard evidence of COVID's disproportional impact on our communities of color. We've seen the violence enacted against Black and brown people in this country. There's a moment here. I think the Atlantic described perhaps the protests that are occurring across the country as one of the greatest civil rights movements in our history, just by pure numbers. And it appears to be gaining it has absolutely gained a life of its own. And we're now to this point where is 209 relevant? I think it is. And Thomas, I'm going to turn to you to talk about perhaps something whose time has come, which is Prop 16.
Absolutely. Proposition 16, which is a straight up repeal of the language that was put into our state constitution by Proposition 209, is on our ballot. Certainly after the hard work of legislators like the two that we have here to put it on our ballot. Took a 2/3 vote to get this on our November ballot, and it's not easy to get a 2/3 vote. But I think it came out of a recognition that really over the last near quarter century, Prop 209 has not served our state well. It has not served our state well as a state that strives to have us all come together and provide opportunity for everyone. And we recognize that there is a new context. Now, some of that context has emerged over the last 24 years. Remember, I pointed out that Proposition 209 was opposed by supermajorities of all voters of color. In addition, women of all races voted 52% against Proposition 209. So here, 24 years later, our electorate has changed. It's still not quite a match to our population, but it is a better reflection of the population of the state of California, where now 42 to 43% of registered voters in the state of California are people of color. That's 27% Latino, 10% Asian American, and 5 or 6% African American. That's significantly different from 24 years ago. But we also know that there are progressive folks in all communities, including in the white community, men and women, who recognize an obligation in this day and age to really take steps to address the systemic racism that we continue to see embedded in our government and societal trends. So the murder of George Floyd and the national conversation that has deepened beyond the previous racist police actions that we have seen, the deepening of that, the discussion of that has led to increased and acknowledged recognition of systemic racism and systems that don't provide equal opportunity, that don't treat everyone equally, that in fact treat people differently based on race. I think that has also contributed to the important moment that we're in. And California has a chance to be a real leader. As Assemblymember Gonzalez pointed out, the proponents of Proposition 209 made a concerted effort to have it replicated around the country, and they succeeded. in 8 other states. And the most recent was 10 years ago in the neighboring state of Arizona, where they enacted a clone of Prop. But that effort to export it from California, we now have a chance to reverse the trend and push in the opposite direction in California if we embrace this opportunity for all.
Assemblymember Gonzalez.
Yeah, sorry.
Go ahead.
I just want to add, I think this, and I think when people voted for it, those people who believed, right, that somehow it was going to bring us this solution, that we were going to become a race-blind society. I think what's happened this year is people realize that didn't happen. Those of us from communities of color realized over the past 24 years, there was no way things, had suddenly become race blind, that there was no way things became gender blind. But I think what happened with George Floyd and some of the protests is may have originally not supported these efforts, realized that this was a failed experiment. It was a failed experiment that really has hurt our community. And I know in my own, I think often, and we've been trying to address it recently, this idea of, if you look at Latinas, right, Latino women, and talk about the disparities that we face in this state when it comes to economics, when it comes to equal pay, we are the least paid subgroup, if you will. You have to drill down into both race, our ethnicity, and gender to realize we get 44 cents on the dollar of our white male counterpart. 44 cents on the dollar. That's nowhere even close to what white women are making. And people who want to tear that back and say it's because of choices we make or fields we go into. If you look at female Latina surgeons who are making 42 cents on the dollar of their white male counterpart, you have to ask what's going on. Well, it's not enough to ask what's going on. We have to have programs that actually seek to correct that, because we can't correct it without being having programs that specifically target both gender and ethnicity. That's what's been missing, And so I think we've seen these outcomes, and for the world to see now on a stage, they've seen some of the outcomes of the lack of outcomes in a race-neutral policies. That it's time to go back to see what kind of promises, what kind of opportunities that we can provide to those, whether they're economic, whether they're socioeconomic, or whether they're just based on policies that we have to take into account race, we have to take into account ethnicity, we have to take into account gender as a government to fix this kind of structural institutional problems.
Assemblymember Chu, Lorena talked about a failed experiment, and I think we've all heard arguments that this is an experiment worth continuing. How does one address that? And it's certainly arguments that have been posed to me by members of the API community. How would you address those types of arguments that it should continue to be race neutral?
Well, certainly within the API community, we've had a very robust discussion about this topic, and I think unfortunately there have been a lot of sort of myths and untruths that have been pushed within our community, specifically around higher education. There are, for the most part, a subset of first generation, typically Chinese or Korean immigrants, who believe somehow that their kids will not be able to move farther in the UC system if this measure were to pass. So that's sort of the myth. That's the rhetoric. The reality is, since Proposition 209 was put into place, we've actually seen API numbers in our UC schools drop. There's also a myth that somehow if we didn't have Prop 209, we would immediately have quotas, which, as I think Tom alluded to before, would be completely unconstitutional, or I think Lorena mentioned, under the 1978 Bakke case. So part of our challenge has been around sort of educating our community on what this is about. But the fact of the matter is, in the last 6 months, so many folks within the API community have really come around. We have over 100 API organizations, major community leaders that are in support of this, including our API Legislative Caucus, who understand that what's at stake are billions of dollars of contracts. What's at stake is being able to see if we're going to have more first responders who come from our community, if we're going to see more teachers, K through 12, or even in higher ed, who come from our API community, and dealing with all of the challenges that we see. But fundamentally, in 2020, we know, everyone knows, that we have amazing racial disparities when it comes to this pandemic. We have amazing racial disparities that we're seeing as a function of racism. And George Floyd exposed the incredible systemic bias against all of us. And really the question I pose to folks is, wouldn't the world be a better place, maybe, if we had more African-American police officers or more African-American police chiefs, or at a time when our Latinx brothers and sisters are seeing the most intense healthcare impacts? Shouldn't we have scholarships for Latino and Latina doctors in the medical field, or for API communities? We've seen hundreds of Asian businesses that have been targeted because of anti-Asian racism. We could move forward with programs that target, say, Asian American businesses that have been victimized due to anti-Asian hate. But we're challenged from doing that because of Proposition 209. Or, how are we going to deal with gender issues in the workplace? Can we think about setting up, say, STEM camps for young girls in elementary school in a way that we can't right now because of Proposition 209? By overturning Prop 209, by passing Prop 16, it opens us up to considering all sorts of things. It doesn't force us down any particular path, and it certainly doesn't allow us to move toward quotas, but allows us to think about inequities and injustices and whether there are targeted ways for us to consider race, because we all know race matters. And fundamentally, that's what this discussion is about.
Thanks, David. Thomas, you talked, actually gave us quite a bit of information of why the time is right in terms of voter support for Prop 16 to pass. Assuming that it does pass, what would implementation look like? Something Member Chu talked about new opportunities to target thoughtfully. The law has changed in the 20 years. So if you could take us through the considerations that we'd have to make in implementing programs that accounted for race, among other things.
Well, it's absolutely, in the last 24 years, what else has changed is that the U.S. Supreme Court has further narrowed the ability nationwide to engage in race-conscious, gender-conscious programs. That is through 4 different cases related to higher ed since Proposition 209 passed, the 2 University of Michigan cases, Gratter and Grutz, and then 2 different occasions that the Fisher versus University of Texas case went to the U.S. Supreme Court. And in employment, we also saw the Ritchie case out of New Haven, Connecticut, where the Supreme Court further defined and narrowed what could be done in the realm of affirmative action in employment by government agencies. So what we see today is you have to engage a very rigorous analysis before you can actually implement any sort of race or gender conscious affirmative action program in any of the realms that we're talking about. Now, that rigorous analysis means looking very carefully at the racial and gender disparities that continue to occur in education, employment, or contracting. And it means also looking at, in order to comply with the narrow tailoring requirement under the Equal Protection Clause as interpreted by the U.S. Supreme Court, it means looking carefully at race and gender neutral means, first, of addressing those disparities without resorting to race or gender conscious programs. If you implement a race or gender conscious program, you also have to be very careful about continuing to evaluate it, continuing to evaluate the need for it, whether it continues to serve a government interest that is sufficiently high. You have to continue to ensure that you are attending to the various means of addressing the disparities that you see. So what that means is that government agencies in education, employment, and contracting in California would begin to engage in that kind of rigorous consideration and analysis of what can be done to address the disparities. First, documenting the disparities, identifying what causes them, and looking at what are the means to address those causes of ongoing racial and gender disparities. What that basically means is some of the most important changes that could come as a result of Proposition 16 may actually be race neutral and gender neutral, because for the first time in 24 years, our government policymakers would have the opportunity, the incentive, and indeed, I think, the pressure to engage in that kind of rigorous analysis that's behind the US Supreme Court's support for affirmative action programs. We haven't had that kind of rigorous analysis and rigorous consideration of these disparities in California, because with Proposition 209, there was no reason for any policymaker to engage in that kind of close look at racial and gender disparities, that kind of close look at what causes those disparities, that kind of close look at what tools might be at our disposal to address those disparities. We haven't engaged in it because Prop 209 in the end foreclosed any consideration of the most important potential measures to address those disparities. So what we will see is, as Assemblymember Chu has suggested, a very careful, close look by all of our policymakers at what can be done to address these evident disparities.
Thanks, Thomas. Assembly Member Gonzalez, looks like we're at the 10-minute mark, and I'm going to, we've opened it up for questions, but in the interim, if you wanted to provide any closing remarks as we wrap up.
I'll just say, I know that there was some comment about not hearing the affirmative action, this attack on affirmative action causing shame. And it has been rewarding, I think, for me and so many of us who have been able to talk freely about being recipients of affirmative action. I remember taking a law school class from Kim Crenshaw right after Prop 209 passed, and her a law school class on critical race theory, and her telling us as students of color to always proudly admit that we were beneficiaries of these programs, because one day we'd get to a point where other people could understand what these programs contribute to, right? I think David brought up how the Assembly has more Asian American legislators than any time in history, largely because of affirmative action. All of them kind of in our age range that are still here. Same with the Latino caucus. You know, there are more Latino legislators kind of in that, you know, I don't want to out us all, but nearing 50, who were all, you know, beneficiaries of affirmative action and can state it so freely and say, see, it worked. Without these programs, I would have never had an opportunity to attend Stanford University or Georgetown or UCLA Law School, or graduate with fewer, you know, without debt. I would have never had these opportunities to go into public service, unlike so many of my colleagues who went to a big law firm to make a lot of money, because I didn't have that debt, because I had race-based scholarships, because people recruited me and taught me about what I could do through a law degree, being a person of color. Programs that went away, you know, programs that no longer exist in the public sphere because it was illegal, and some because of the mass fear that it caused when people would talk about race and gender after Prop 209. And so we look around, and it is nice, and I think great for us to be able to say, yes, we're products of affirmative action. It worked for us. I don't think I'd look at any of my colleagues and say, oh yeah, that's, you know, they're a substandard student, or they must have been. I think I'm pretty impressed with the resumes and the achievements of so many of the legislators who are in our age range and are people of color who really benefited from that. And I hope that our next generation will be able to benefit as well.
Thomas, closing remarks?
I too will say there's absolutely no shame in being a beneficiary of affirmative action. Affirmative action is a powerful tool to benefit all of us. So we're all beneficiaries of affirmative action, because it allows us to question some of the selection mechanisms and criteria that we've inherited from those in the past that are really far from perfect. Indeed, they are discriminatory and imperfect. One example, we have depended too much on standardized test scores in making higher education admissions decisions, even though we know and have known from the very beginning that these tests have a discriminatory effect And we have also known that they have little or no correlation with success in our universities past the first year. But why do we continue to believe in them? Why do we continue to use them? Because we inherited them. And because folks then become really ingrained in their belief in criteria that we have inherited. But affirmative action is a tool for us to question the criteria and selection mechanisms, whether it's those standardized tests or whom you know, the old boys network, as it has been called, or other preferences that we have in place, including preferences for legacies, the children of graduates of some of our flagship universities, private and public, around the country. So affirmative action is something to be proud of. I'm proud of being an affirmative action beneficiary because I know we're all beneficiaries if we use affirmative action as a tool to really question and hone and improve the selection criteria that we have used for far, far too long. And that's the kind of power that Proposition 16 will unleash for California. It's opportunity for all of us.
Well said. Assemblymember Chu, closing remarks?
I think I'll just add a few quick points. So for anyone who may still be wondering where you stand on this issue, I'm going to ask the hypothetical question that we were all asked in law school as you think about it, which is, if you did not know at this moment what race or gender you would be, right? If you were an unformed embryo and you didn't know if you're going to grow up to be black or white or Latino or Asian or a woman or a man, assuming the disparities of race and gender that we see today, would you want to have programs that would consider race or gender and how to address the disparities or not? Because I would suggest, not knowing where you might be in society, we would be better off having programs that try to balance out where folks are going to be in the race of life, where you will be when it comes to the opportunities that you will or will not have. Because maybe you'll be lucky and you'll be born a white male and you'll be ahead, but maybe you'll be born a Latina woman and be set back. And if you don't know before that happens, what set of rules would you want to have in place? The second thing I would say is it has now been 24 years since we tried this experiment of eliminating the idea that race ought to matter. And so if you were the age of 42 or younger, you've never had an opportunity to make this decision. And what we're asking for is now, a generation later, let's let California decide again. The last thing I want to say is, if you are convinced that this is the right way to go, this may seem like a no-brainer to you, but it's certainly not a no-brainer for many members of the public who are still confused about this. And we're really here, as Harvey Milk would say, I represent the district that Harvey Milk lived in. We're here to recruit you. We hope you might consider getting involved and taking part in this movement, because I do think this is one of those civil rights fights that is a generational fight. And it's our hope that this is the generation where we overturn things and we get to bring things back to bend that arc, as Dr. King would say, and it's always the right time to do what's right.
Thank you. We do have a question about whether reparations would be an effective means to address the historic discrimination against certain segments of our population, specifically African Americans. Thomas, I'll let you take first crack at that.
Sure. I think people have different definitions of reparations, but I think in almost every definition there is a recognition of an obligation to engage in the kind of rigorous analysis of what systems we have in place and how much of an obstacle they continue to present to folks who come from communities that in the past were really the targets of nationalized racism. By nationalized racism, I mean government-sanctioned racism. That's both in slavery for the African American community, it's in genocide for the Native American community. Certainly for my Latino community, the national government had to foster racist thinking about Latinos in order to justify taking over half of what was the nation of Mexico. It had to be justified in some way, and it was justified by our national leaders by adverting to racist tropes about those who live there. For the Asian American community, seeing national legislation that specifically targeted and excluded Asian Americans from coming to this country and from naturalizing once they were here. So we know that reparations for national policies has to involve looking at all the policies we still have in place and the kinds of intentional or unintentional discriminatory effects they have. That includes steps like Proposition 16 in my mind.
Well, I just wanted to extend a warm thank you to our esteemed panel, Thomas, Assemblymember Gonzalez, Assemblymember Chu. I really appreciate you taking the time to walk us through the issues. David, you sort of took us beyond 60 years, and we'll get to now what I believe to be a new future for Californians through Prop 16. So thank you very much.
Thanks all.